Hello, everyone, and welcome to Uncivil Law. I hope you are having a fantastic day. And we are here with yet another edition of Supreme Court React. Today's video will be a reaction to the oral argument in Georgia versus publicresource.org. And I'm going to read the description of this from Oyez to get us prepped. The official code of Georgia annotated is a compilation of Georgia statutes accompanied by various annotations, quote, consisting of history lines, repeal lines, cross-references, commentaries, case notations, editor notes, excerpts from law review articles, summaries of opinions of the Attorney General of Georgia, summary of advisory opinions of the State Bar, and other research references, unquote. Although the code itself states that annotations are part of the official code and the statutory provisions, quote, shall be merged with the annotations, unquote, Georgia law states the annotations themselves do not have the force of law. The annotations are prepared pursuant to an agreement between Matthew Bender and Company, an operating division of the LexisNexis Group and the state of Georgia, under which the state exercises pervasive supervisory control by way of its Code Revision Commission, a body established by the Georgia General Assembly. The commission is comprised of the Lieutenant Governor, 4 members of the Georgia Senate, 4 members of the Georgia House, and 5 members appointed by the President of the State Bar of Georgia. Publicresource.org is a nonprofit organization with a mission of improving public access to government records and primary legal materials. In 2013, PRO purchased all 186 volumes of the print version of the official code of Georgia annotated and its supplements, scanned them, and upload them to its website to be freely accessible to the public. It also distributed digital copies to Georgia legislatures and other organizations on its website. The commission sent PRO several cease and desist letters on the ground the publication infringes on the state of Georgia's copyright in their work, but PRO persisted. The commission sued PRO in 2015 in federal district court, seeking injunctive relief. PRO acknowledged its publication and dissemination of the official code of Georgia annotated, but denied that state of Georgia holds an enforceable copyright in the code. The district court ruled for the commission, finding that because the annotation of the official code of Georgia annotated lacked the force of law, they are not public domain material. On appeal, the United States Court of Appeals for the 11th Circuit reversed, finding that because of the way they're written and integrated into the official code, the annotations in the official code of Georgia annotated are attributable to the constructive authorship of the people and thus are intrinsically public domain material. To reach this conclusion, the 11th Circuit examined the identity of the public officials who created the work, the authoritativeness of the work, and the process by which the work was created, finding that each of these markers supported the conclusion that the people were constructively the authors of the annotations. The question presented: does the government edict doctrine extend to, and thus render uncopyrightable, the annotations in the official code of Georgia annotated? So that is what is going on here. You're getting some audio popping. I have no way to solve that problem at all. I turned off all the filters related to, I don't even have noise gate anymore. So that is as good as it gets. So VPN is not working. VPN is not on. If you're getting popping, there's nothing I can do about it. So, I don't know. But we do what we can. Okay, so we are going to listen to these oral arguments. My view going into this, so that we can filter against my bias, my view going into this is that even if you assume that the annotations had the force of copyright when they were created, which I think is a reasonable assumption because, they're being reviewed, they're being created under contract by a private association on behalf of the government. The government has some supervisory roles, but, it's not being created by the government, it's being created by a private entity. So I think you can probably get as far as there's copyright interest in the annotations when they're copyrighted or when they were created. For me, this all falls apart as soon as they become part of the official code of Georgia. At that point, whatever copyright interest they have was effectively extinguished by virtue of the state essentially commandeering the copyright. So my view is that even if they were copyrighted, you can just copy the code, and if Matthew Bender or LexisNexis has a copyright interest in this that Georgia is violating, then sue Georgia for your copyright interest. Of course, that assumes you can sue Georgia for the copyright interest, which itself is being decided right now in a parallel case also being heard by the United States Supreme Court called Allen versus Cooper. Oral arguments for that have already happened, where basically the U.S. government's trying to decide whether or not you can sue a state for copyright violation at all. But you can sue or not, and that's your only remedy. You don't have the remedy of maintaining the copyright interest. So my view is that even assuming there was a copyright interest in this thing, it became extinguished the moment it became part of the official law. And whatever copyright interest you had that was infringed by that act of the government, go fight it out with the government if you can. Otherwise, well, you're just plumb out of luck. Sorry about that. So that is my view on this. I have currently predicted a 9-0 decision to affirm. So we're going to listen to this and see if anyone changes my mind or if we change my prediction, and that is going on. Evil Tribble says, do patent lawyers interact with copyright law in their practice? Not really. No. No. I don't, at least. Not an issue I deal with. But that being said, I studied a lot of intellectual property law, and so I know my copyright law pretty well, and, so I'm, I think, reasonably confident to offer an opinion on this area. So let us see what is happening.
We'll hear argument next in case 181150, Georgia versus publicresource.org, Inc. Mr. Johnson.
Mr. Chief Justice, and may it please the Court. The 11th Circuit held that annotations to Georgia's official code are categorically ineligible for copyright protection. That holding conflicts with a straightforward application of the Copyright Act's text in this Court's precedents. Starting with the statute, Sections 101 and 103 of the Act expressly provide that annotations are copyrightable derivative works. Nothing in the Act supports stripping Georgia's annotations of copyright protection merely because they were prepared by a contractor on behalf of a state agency. Therefore, the crux of the parties' dispute is whether this Court's 19th century precedents support a decision different from the one that would be reached by applying standard interpretive principles to the Copyright Act's plain text. They do not. In fact, those decisions strongly favor Georgia. Together, they hold that while judicial opinions are not copyrightable, annotations added to opinions by a court's official reporter are copyrightable works of authorship. Similarly, while statutory text is not copyrightable, annotated research references are eligible for copyright protection, even if they appear in an official codebook like the OCGA. As a diverse coalition of states has explained, affirming the decision below would scuttle numerous states' regimes for publishing annotated official codes. Absent direction from Congress, this Court should not extend a judge-made doctrine to override the systems established by numerous states' democratically elected governments. I invite questions. But as a diverse, so PRO's case rests heavily on an expansive interpretation of just a few sentences of this Court's 1888 Banks decision. But the Banks case really just explained its rationale in a single sentence. And that sentence says that the whole work done by the judges constitutes the authentic exposition and interpretation of the law. which is binding on every citizen and is thus free for publication to all. So we read that sentence as establishing the principle that a work is not copyrightable if it is of a type that can serve as a vehicle for establishing binding law.
What do you understand the significance to be of the fact that these annotations, the references, are official? Does that give them more weight when they're cited to the court?
No, and I think that the thing that's official is the code. So it's the official code of Georgia.
Whether whatever the additional material is included in.
It does appear in the same publication. That's correct. And I don't think that that makes a difference for purposes of copyright under this court's precedent. And I think that that's clear from Wheaton and Callahan. So in both of those cases, the court said that a court-appointed official reporter could hold copyright in annotations that appeared in the reporter volumes. So this case is really just the legislative analog of Callahan. In Callahan, the court held that the official reporter could hold copyright in things like headnotes at the top of a decision. And if you look at the judicial decision summaries in the OCGA, they are materially indistinguishable from those headnotes.
So that's actually pretty good precedent for the state of Georgia, arguing that in the judicial context, judicial decisions themselves are not copyrighted, but these headnotes and annotations, there have been case law, even where they're prepared by an official reporter, basically prepared by a government agent or government official, that nevertheless those headnotes or annotations are copyrighted, even though they're published. Now, that could be extinguished by a state law, of course, but in the absence of that, there's still a copyright interest in that according to those cases. And so he's saying, well, this is the legislative equivalent of that. Yeah, I mean, that makes a lot of sense to me. I mean, it's, you know, if it were a state employee, the logic would be the same. The fact that it's a contractor, the logic is the same. So I think it's actually a pretty good argument for Georgia. It being me, I would just as soon overrule the prior case law that said there was a copyright interest in the headnotes and the annotations rather than, you know, affirming that and sticking with it. So I just as soon overturn the precedent, but it's a pretty good argument with for Georgia. So pretty solid argument from him.
But why isn't the legislature like the judge? Did the judge put his imprimatur on the annotations not copyrightable of the syllabus? And here it's the state legislature. Why do you treat the judge and the state legislature differently?
Well, I think it's different because the General Assembly is not enacting individual annotations through bicameralism and presentment. So the annotations are first prepared by a commercial publisher, so by a contractor, and they do that subject to the supervision of the Code Revision Commission.
But they do it as what do they call it, authors for hire. So the one that would hold the copyright would be the state.
The state does hold the copyright. That is correct, very much like how an official reporter held the copyright in Wheaton and Callahan. So here, the Code Revision Commission, acting on behalf of the state, obtains a copyright for the state. But I think the crucial point under Banks is that the annotations are not individually reviewed by legislators. They do not go through the process of bicameralism and presentment.
Well, but counsel, aren't they approved? I thought they were at least approved as a whole by the legislature.
So I think the 11th Circuit's decision is perhaps a little confusing on this issue, but I don't think that there's any disagreement about the underlying facts. The answer is, as the 11th Circuit said in its opinion, the annotations are not individually enacted.
I understand that. I posited that in my question to you.
Right.
Aren't they approved as a whole by the legislature?
So what the legislature does every year is passes a Revisor Act, and the Revisor Act reenacts the code, including OCGA 111, which calls for the statutory text to be merged with the annotation.
Okay.
So that, for me, is a grounds to distinguish on the judge's case. That's grounds to distinguish factually. So, like, if they had just prepared them separately and published them separately, then I think the prior case law dealing with the judicial headnotes and judicial annotations would be on point, right? So like because the judge makes their decision and it's done, and then like the reporter comes on and adds stuff, and then they just publish it all. So like there's no like second act by the judge that like incorporates it back. So like you have the judge's decision, which is done and separate, and then you have the annotations and headnotes, which is produced separately, that has a copyright interest. So you can distinguish it on the facts. But here, there's a law specifically saying, and apparently every year they in fact do this, where they say like, we are, as the legislature, positively taking an act to reincorporate this back into our code. So like from a factual standpoint, I think you can distinguish this on the fact, because like that act is enough to separate it out factually. So like on that basis, you wouldn't have to overrule the precedent. You could distinguish it. And by the way, thank you, Barry Blunick, for your $2 super chat. Every bit of super chat really does help. I really appreciate the money. It really helps. It goes back into promoting the channel. It goes back into helping me pay people for work on thumbnails. Helps me, basically help the channel grow. So it really does make a difference. I really do appreciate the support. So let's carry on with the thing and see what else we got.
All right. So if that's the case, and you include the word official on it, presumably you're doing that to create some value for the reporter. Why would we allow the official law enacted by a legislature, equivalent of being approved by the judge in annotations, as Justice Ginsburg indicated, why would we allow the official law to be hidden behind a paywall?
So I don't think that adopting our position would cause the official law to be hidden behind a paywall. First, the law is available on Lexis's website, and also PRO is free.
But not the official annotations that the legislature has in some fashion or another given its official approval to.
The annotations are not the law, so the law is not behind a paywall. Also, the annotations are available.
Well, you're not arguing that it's purely – I thought you had disavowed the argument that it's only things that bind for which copyright's unavailable.
So our position is that if a work is of a type that as a class can serve as a vehicle for establishing binding law, like judicial opinions.
And aren't annotations in that category, aren't they frequently used by state courts as indications of the legislature's intentions?
No, not the type of annotations that we're talking about here. We're talking about traditional annotations that are research references or finding aids. They're things like, to give an example, from JA 699, one of the annotations that we're claiming copyright in says, for a survey article on trial practice and procedure, see a
So you're disavowing that they're ever used by state courts as indications of legislative intent? That never happens. That's a representation you're making to this court?
Yeah, the annotations would never be used as an indication of legislative intent like you would cite a legislative history material.
Why does
No, go ahead. Does that apply to all of the annotations in the official code? Does it apply to annotations made by the Georgia Bar?
Good question.
So it applies to all the annotations we're claiming copyright in. The Georgia Bar, I think of those as comments, not necessarily annotations. They're provided by the Georgia Bar Committee to the Code Revision Commission. The Bar Committees ask that they be included in the code, and often the people who write them are involved in actually drafting the statutes. Georgia courts do cite those comments, but we are not claiming copyright in those annotations. PRO is free.
Well, that's a little bit confusing, because now you've got annotations that like are copyrighted and aren't copyrighted in the same place. So like, how are you supposed to know which ones are copyrighted and aren't copyrighted? How are you supposed to distinguish the copyright interest in these annotations? So that's a practical problem for someone. Like, if you're saying, well, these annotations don't have a copyright interest, like which other ones does that apply to? Good question. I don't know. So, yeah, let's carry on.
to copy them, and in fact, they appear in West's unannotated or unofficial.
What is the theory that distinguishes those annotations from the other annotations?
I think that, first of all, the author is different. So it's the state bar. The state bar, if it wanted to make a copyright claim, would have to be the one that's making the copyright claim. I don't think that – I think probably those would not be copyrightable if the state bar was trying to make a copyright claim.
Why?
I think there could be maybe a debate or dispute about this, but I think that they probably would not be copyrightable because they are offered for the purpose of providing a gloss on the text, the drafter's intent for the statutory text in some cases, and courts in Georgia have treated them as such.
Why would the Georgia bar have particular insight into the intent of the legislature in enacting a provision of law?
Well, often my understanding from reading the introductory text to these comments is that they're often drafted by people who were involved in drafting the legislation. So even though a bar committee member isn't in the legislature, they're often involved in assisting with the drafting of the legislation. Now,
but a lot of people could be involved in the drafting of legislation. It could have been proposed by some interest group. It could have been something that was worked on by a law professor. So what distinguishes those? Those would be copyrightable, wouldn't they be? If somebody like that wrote an article. So what distinguishes them from the comments of the Georgia bar?
Very good question, Alito.
So I think it's perhaps different because the Georgia bar has specifically asked for these comments to be included in the OCGA, and Georgia courts have treated them as having some authoritative weight. So I think that that's what makes it different. But I want to stress that the comments are not at issue in this case. So I'm just trying to give my best views about whether those are copyrightable or not.
I didn't actually, in reading this brief, understand that. I'm not sure the court below did, because they relied on the comments as one of the reasons for why this was attributable to the state, for the very reasons you're giving, that the state asked for them, that the state commission who prepares them is involved generally in the drafting of the law. And so I don't think they separated out that the only thing you were seeking copyright protection for is the research comments and the tell me exactly which part of the annotations you're seeking.
It's the materials listed at JA 496 to 497, and I can march through those.
No, that's all right.
But
I do have a question. If I read Wheaton says anything prepared by the judge can't be copyrighted. That includes headnotes, which are comparable, I think, to summaries that might be included in these annotations because it's prepared by the judge. It remands to see if Wheaton was not an independent contractor and was an independent contractor and actually sought the copyright. Banks says if you are a separate entity, you can do this. But this is a work for hire. And I go back to what Justice Gorsuch was asking you.
Midnight Rose said, who is this attorney that Georgia has sent? I feel like he's either wet behind the ears, unfamiliar with the state argument, or pulling it out of his butt. You know, I'd have to disagree with the way that you're reading what he is doing. You know, he like every attorney, you know, has problems, right? He has problems in his case. And so he has problems like this case law, and he has problems that Sotomayor is beginning to elucidate, like anything prepared by a judge. And so the State Bar of Georgia is a official government organization. So they're the ones doing it. They're the ones asking to be incorporated. So it's a state entity that's preparing the comments and putting them in, you know, as part of a state entity. So, you know, it's the State Bar of Georgia. They're part of the judicial branch, but it's part of the government. they're the ones creating the annotations. And so, versus annotations created by a private entity. And so he's trying to very tactfully and very carefully splice this difference so that he's like, well, this stuff isn't covered, but this stuff is covered, and here's some reasons why, and here's some stuff, and like the fact that what makes it different is that when the State Bar of Georgia did it, they anticipated it on the front end, and basically the argument from the other side is that when the state of Georgia on the back end incorporated it in, it wasn't quite the same thing. So like he's trying to make a factual legal distinction. So, I don't know if it's necessarily the position I would take. I haven't thought through every possible position I would take if I were arguing this position. Like I wouldn't necessarily know if I would go, well, the annotations are in or the comments are part of the copyright, or I don't know how I necessarily parse this, but I don't object to the way that he's parsing this. I think it's a very reasonable legal position. It's a delicate balance, but he doesn't strike me as inexperienced. He doesn't strike me as unknowledgeable of the record. He strikes me as someone who's taking the situation and trying to maximize what his client is trying to do. So he seems perfectly reasonable to me. That I don't think that makes it a good argument, because I think he's ultimately wrong, but I understand what he's doing. I appreciate what he's doing. It's a perfectly reasonable line of argument. So, I disagree that he's inexperienced or unfamiliar. I think he knows his stuff very well. He's doing a good job with a difficult case. So, not too bad.
The state is the one who's requiring this to be done. It reviews it. It approves it. It is setting it out there as a merged document with the actual laws. It may have merger doesn't mean it's actual law, but neither are headnotes actual law. Dicta is not actual law. And no one's arguing, you're not arguing under Banks or any of the other cases that the state couldn't get a copyright in headnotes it prepares or in the dicta in its judicial opinions. So why isn't authorship really the most important factor?
I think
if it's going to explain the law, either by reference to comments or by reference to cases that reflect its intent, isn't that an explanation, an official explanation of the law?
So I think we win if authorship is the standard, and I think that that's basically the United States' test, and the United States agrees that we win under that standard. And on the question of what are
No, it doesn't, because it sort of limits it. It thinks that it's not official in some sort of unofficial way, even though it's approved by the legislature, it's merged by its very terms. It's a contract for hire, which means you treat it like an employee. If a law clerk prepares my headnotes or my summaries, I don't think I can get he or she can get a copyright in it. I don't think I can get a copyright in it, even as a work for hire.
Well, I think that the answer can't be that the fact that this is an official document makes a difference for copyright purposes under Wheaton and Callahan. Again, those were official reporters. And if the officialness of the document renders it uncopyrightable, then all state government documents in some way are official. They come from the state government. But the one thing that we know is that Congress made the policy determination to allow state governments to have copyright. And it's important to emphasize that Congress did this with a 1959 study and 1961 report in front of it saying that annotations by state government employees are copyrightable under current law.
Why does Georgia have an official annotated code? Like, why not just an official code?
I think it's for the benefit of readers so that those finding aids are present. And I think the reason why they made it official is because they wanted to have an annotated version subject to a price cap so that it would be available to people at a relatively low price.
Probably governmental. Look, I thought this isn't that difficult. If a judge does something in his judicial capacity, it is not copyrightable. If a legislator does something, or a group of legislators, in their legislative capacity, it is not copyrightable. Well, who cares who the author is? There are public policy reasons that have existed forever in the law that you make those two things not copyrightable. The executive is harder to separate out, but you could do it. Now that, I think, is basically the SG's position. If it's not in their official capacity, if it's simply a summary or it's a comment upon something done in an official capacity, it is copyrightable, even though it be done by a sworn public servant. All right? There we are. I think that's roughly the SG's position. When I read that, it seemed pretty sensible to me and consistent with the precedents. That you have a somewhat different position. So I guess my question is their position, at least if I understand it, acceptable to you?
The SG's position is acceptable to us, and we win under that standard. Perhaps it would be helpful for me to explain quickly why we do win under that standard. So the Lexis and the Code Revision Commission are not acting in a lawmaking capacity when making these annotations.
Thank you, counsel.
Yeah, not bad. Not bad. It's a good line of argument. He's well prepared. He's thought about the issues. He has a reasonable thesis, a reasonable argument of the case. He points out correctly that the United States copyright law allows states to have some copyright interest in some stuff. So, okay. Fair enough. I mean, it's a reasonable, cogent, consistent line of argument. He tries to separate like official government action. He tries to separate stuff that's done like after the fact from this. He tries to separate stuff. So he has a plausible line of argument. Not bad. Let's see what else we got.
Mr. Yang?
Mr. Chief Justice, and may it please the Court, this Court in Banks determined that there was a consensus that no copyright exists in a work by, quote, judicial officers in the discharge of their judicial duties, unquote. Banks then held that a judge who in his judicial capacity prepares an opinion or decisions and other materials is not regarded as the author within the meaning of the copyright statute. Those principles from the judicial context also apply in the law-making context. So, if a lawmaker acts in his capacity as a lawmaker and creates a work in the discharge of his law-making duties, that is, within the process for creating law, no copyright exists. Now, in this case is going to be controlled, however, by Callahan. Callahan upheld a copyright in annotations to judicial decisions by an official court reporter, a salaried public officer of the court who was appointed and removable by the court. Such annotations are written after the fact as an attempt to accurately describe or provide context for the underlying source.
Mr. Yen, I'm sorry. Finish your sentence.
Well, I was just going to say that the annotations here are research aids. They are created after the fact. They provide a comprehensive, not a selective, selection of materials related to the statutes. There's no approval for the substance. And in fact, the context is easier than Callahan because it's made by—
Don't finish it that far.
Okay. All right. I'm happy to stop.
I'm glad I asked you to finish it because you stress that the Commission doesn't do anything with respect to these annotations. Suppose the Commission did do something with respect to these annotations. They didn't write them themselves, but they supervised the process carefully. They imposed some kind of editorial standards. What then?
I don't know that would make a difference to the bottom line. Our understanding of the test that draws from Banks is that when a lawmaker acts in his capacity as a lawmaker in the discharge of lawmaking
duties. Are you
duties,
saying that the Commission just doesn't count as a lawmaker?
And they're not discharging lawmaking duties. Yes. Because the Commission is composed of 15 individuals, 5 of which are not even in the legislative process. In Harrison, the Supreme Court of Georgia recognized that those non-legislative people could actually make the difference in any kind of decision.
But the legislature sets up this commission and puts a bunch of its members on this commission.
Yep.
And let's say in my hypothetical world, this commission actually takes its job seriously and imposes some editorial standards for what will and will not go into the annotation. Still,
Same result, but it's also in the context of the rest of this case, Section 111. The statutory portion of what's produced by Lexis in the commission is enacted as statute. But Section 117 explains that the notes, the annotations, and the other things are for convenient reference and do not constitute the law. Every year they enact this, and there's a good example.
Well, but people look at the annotations pretty carefully as guides to what that law is all about.
Well, if they looked at
if the commission is basically involved in what should be in and what shouldn't be in to explain to people what the law means, why would that be copyrightable?
I don't think they're actually explaining what the law means. They're describing what this is better than Callahan, because in Callahan, the reporter was legally superintended by the court, right? Could have been removed by the court, was hired by the court, appointed by the court. Here, they're describing what third parties do, what courts do. To the extent there's any relationship, it's only with the legislature, and even there it's attenuated.
So you think even if the commission actually wrote the annotations, it would still?
That's right, and look what the annotations are. Under this contract, they are intended to be comprehensive. They don't say, this is a good opinion, this is right, this is wrong. They just want to cover the waterfront, right or wrong, accurately describe the judicial sources that are out there, the Attorney General's opinions, law reviews, other types of secondary ALRs, these types of things.
Would it make a difference if instead of the commission it were done by the legislature itself?
I think that would be a little more.
But all they do is describe what judges do.
After the fact. No, I think that would be the same.
Okay.
I think you would.
And let's say it was adopted by the legislature too. And let's say we put the word official on it for whatever good that does, market power-wise. Then what?
Well, if it's done as it is done here, which I think if you look, for instance, in the respondent's brief at pages 2A and 3A, it's prepared. It says the official code is prepared by the Commission, Legislative Council, and Lexis. And then the next page over, it says the statutory portion is a true and correct copy. It's certified. What's official, what's certified is correct, is the text of the statute.
Nice evasion, but if we could just answer the question, I'd be grateful. Let's say the legislature itself does the reviewing of all of the judicial opinions, and then it collects the ones, and then it enacts it, and calls it official or not official. You choose. I don't care. Is that copyrightable?
Yes, if they're doing it in the same way, which is that
because it's not its legislative capacity, right? I mean, that's what it comes down to. It's not its legislative capacity. It's in some other abstract capacity in which a legislature can act.
That is our understanding as drawn from the answer.
Ooh, that's a tough position. I admire his position because Gorsuch has taken this to the wall, right? He has taken this to the wall by going increasingly further and further into state action, right? So what if it was done? What if it was done directly by the commission? He asks. Well, that's okay. Well, what if it was done by the legislature? Yeah, that's okay. So what if the legislature, literally, he says, what if the legislature, in addition to passing laws, what if the legislature also, in what free time it has, somehow gets together and cobbles these things together themselves and passes these things themselves and puts official or not on it, and he still says, yeah, that would be copyrightable. And then he says, well, then you're saying that the legislature isn't acting in a legislative capacity. And he says, yeah. So we've got the legislature, two houses of the state Congress. We got the legislature with the legislators creating things and passing them, and it doesn't qualify as legislative action. I'm a little dubious on that. Theory there, Assistant Solicitor General. I'm a little dubious on this theory of it can literally be the state house and state senate and the literal legislatures, and they're literally the ones doing it, and they're the ones literally passing it and literally putting in a book and literally put the word official on it, and it's not an action of the legislature. Okay, carrying on.
No, then the answer is no to his question. Because the whole point, I thought, is that you go very abstractly. Minnell explains it. I do, says the bride. You can't copyright that. It's being used as a performative. It's not an expression. Now, take that idea and bring it down to the legislature and making laws. Where you have some words on pieces of paper and they are performing a function that is a legislative function or a judicial function, no. It's not solely an expression. It's performing a function, and we don't allow it because to let a monopolist get a hold of that is dangerous.
Well, I don't
and
think
that's what I thought that the argument was as I got.
I'm not sure there's any disagreement. What I intended to say was that the annotations would be copyrightable. The statute would not. If it is a description of what other parties are doing, there's no particular.
I'm sorry, I don't understand. I'm turned between
maybe
two
just to
colleagues,
clarify.
but let me just get to something very simple, okay? Let's assume there are some states that have pro se guidelines. To pro se litigants, this is how you follow the law. Could they copyright those and charge for them and preclude others from copying them and disseminating them?
If, for instance, this is like let me draw an example. When the court adopts rules for federal rules of civil procedure or otherwise, there are often advisory committee notes that explain kind of context.
Is that copyrighted?
We understand that, no. We understand that to be in the context of the rulemaking proceeding.
All right. So why is that different? And I think your brief made it very clear, committee reports, even on failed legislation, wouldn't be copyrightable. Materials prepared for that process are not copyrightable unless the state didn't require them or create them. So why is it that an official guide to an official code where the annotations merge with that code that are prepared by the state, why aren't those copyrightable? Why aren't they like?
There's a few things that are, I think, incorrect in the premise. One, if you look at Callahan, you had annotations by the official court reporter, superintended by the court, combined in a single volume, still copyrightable. So the fact that they're together, not relevant. Second, when we're talking about annotations here, we're talking about a description of case 1. Case 1 says the statute means X. Case 2 means the statute means Y. They reproduce both of them. They're not saying that one
Suppose
is
that weren't true.
wrong.
Suppose the commission, when it supervised, part of its supervision, it looked over the annotations, and it picked out a few that it thought were egregiously wrong in terms of interpreting the law. Would that make a difference?
I think it would start to be a little harder. It starts to sound a lot more like post-enactment legislative history if it were done by the legislature.
A little bit harder, but that's still copyrightable if the commission is saying, no, that's an incorrect interpretation of law? We'll take out that annotation?
I think because the commission is, again, making an observation with respect to what these other parties do. They don't have any particular expertise. It's not the legislature itself doing this.
Okay, now I'm going to go back to Justice Gorsuch. How about the legislature?
Well, if the legislature did that, I think there would be a question whether that is part of the legislative process.
I love this answer, guys. I love this answer. This is exactly what I was saying earlier. I tried to summarize what he was saying. I'm not making this up. He just literally said the same thing. Quote Mr. Yang here. He said, quote, well, if the legislature did that, I think there'd be a question whether that is part of the legislative process. Yep. When I'm explaining things to you and summarizing things to you, I'm not really necessarily making things up. And it's nice for him to just say it in one complete sentence. It's like, here's my analysis of what they're really saying. And then 2 pages later, he just flat out says it. There'd be a question, if the legislature did that, I think there'd be a question whether that's part of the legislative process. Nice. Wow. Fun. Good times.
Isn't that banks? Isn't that potentially Justice Gorsuch's hypothetical, the distinction between Banks and Callahan, or not?
Well, I think Banks.
In other words, can't you give up that hypothetical and still win?
I think we could give it up, but let me take a step back and say we can start looking to the fringes of this case. Mm-hmm. But when we look at the core of what this is about and the way that this has arisen, this test that we think flows from Banks and Callahan is one that
Okay, it just stopped for no reason, but okay. Oh, the audio's done. There's no more audio. There's no more audio. Uh-oh. There's no more audio. Hold on. Hold on. There's no more audio. Uh-oh. Hold on. Please entertain yourselves while I try to fix this problem. Yeah. Talk amongst yourselves. While I try to deal with this issue. Super. All right. Can I get audio this way? Yeah, no. You've got to be kidding me. Wow. You've got to be kidding me. On the Supreme Court website, there's no more audio either. It's wrong on the Supreme Court's website. There's no more audio. Well then. Exciting. That is the end of our analysis, I guess. Well, I will read it to you. I will read it to you, okay? I will read it to you. Sorry you don't get the actual audio, but there is no actual audio. But I will read it to you. Which means I'll be a little less responsive in chat, because now my attention is being diverted in too many places. But I'll do what I can, guys. Mr. Chief Justice, and may it please the court, I think it's useful to remember that the question Georgia presented in this case was whether the government edicts doctrine extends to the documents that lack the force of law. The answer to that question is clearly yes. The United States agree with us that it has to be yes. That is required by this court's decision in Banks. And it seems necessary unless legislative history, agency guidance documents, unpublished judicial decisions are going to be subject to copyright. Now, Georgia hasn't proposed an alternative test, but we've proposed a test that we've drawn from the language in this court's decision, particularly Wheaton as it was understood by Justice Story and Callaghan, which adopted that understanding and asked two straightforward questions. Is this a legal work, and is it published under the authority of the state? If it is, then it can't be copyrighted, and that makes sense because states don't publish authentic state legal works for the purposes of making money or maximizing profit. They publish them so people understand their legal obligations. So you do not need the copyright incentive to ensure these works get made. Stephen Breyer, why is it different if the state, or is it? The state hires an official historian. The historian's job is to write the history of the state of Georgia. After a committee reads it and says yes, they stamp it official. They have a copyright contract, so the state, gets copyright. Is it copyrightable? I think it's copyrightable because why is that copyrightable, and yet a comment made by the professor's cousin, who happens to teach in law school, is not copyrightable? The comment being on the state of law, the comment being the summary of the cases, the comment being the 6 things listed on the page, whatever it was, page 497, the 7 things. How is that different? I guess I want to answer both parts of that question, but I'm going to take the second part first. I don't think a law professor speaking in the voice of the state or something a law professor publishes in a published authority under the state, so it would be copyrightable under our test. Nor do I think that an official state history is a legal work, and so that wouldn't be captured by our test either. And there's a difference because when the state speaks, when the state speaks in the state's voice with respect to legal work, you're asserting a different kind of authority that has value that it doesn't when the state publishes its poetry. Matthew, it's not that the audio doesn't work. It's just that there's only an hour of audio. There's only an hour of audio on the Supreme Court's website. So there's no more audio. The audio I have from Oye is an hour. The one on the Supreme Court's website is an hour. They didn't post the whole audio. They're missing the whole third part of the audio. It's not long enough. So yeah, the link works for all the good it would do me. Oh, it was? Hold on. It cuts out and comes back? I only show 1 hour 56. Okay. Okay, well, never mind. I guess we do have more audio. Well, I guess we won't be doing my my dramatic read. Yeah, I see that. I see where it's highlighted now. So I don't know what happened. Okay, well. Hold on. You guys are awesome, though, for double checking me. Thank you. I really appreciate it and saving my voice. We'll give this another shot.
Mr. Chief Justice, and may it please the Court. I think it's useful to remember that the question Georgia presented in this case was whether the government edicts doctrine extends to documents that lack the force of law. The answer to that question is clearly yes. The United States agrees with us that it has to be yes. That's required by the Court's decision in Banks, and it seems necessary unless legislative history, agency guidance documents, unpublished judicial decisions are going to be subject to copyright. Now, Georgia hasn't proposed an alternative test, but we've proposed a test that we've drawn from the language in this Court's decisions, particularly Wheaton as it was understood by Justice Story and Callahan, which adopted that understanding. And it asks two straightforward questions. Is this a legal work, and is it published under the authority of the state? If it is, then it can't be copyrighted. And that makes sense, because states don't publish authentic state legal works for the purposes of making money or maximizing profit. They publish them so that people will understand their legal obligations. And so you do not need the copyright incentive to ensure that these works get made.
Why is it different if the state, or is it? The state hires an official historian. The historian's job is to write the history of the state of Georgia. After a committee reads it and says yes, and they stamp it official, they have a copyright contract, so they get, the state gets the copyright. Is it copyrightable?
I think that is copyrightable because
why is that copyrightable, and yet a comment made by the professor's cousin, who happens to teach in law school, is not copyrightable? The comment being on the state of the law, the comment being a summary of the cases, the comment being the 6 things listed on page, whatever it was, page 497, the 7 things there. Well, how is that different?
I guess I want to answer both parts of the question, but I'm going to take the second part first. I don't think a law professor is speaking in the voice of the state, or that something a law professor publishes is published under the authority of the state. So that would be copyrightable under our test. And nor do I think that an official state history is a legal work, and so that wouldn't be captured by our test either. And there is a difference, because when the state speaks, when you speak in the state's voice with respect to a legal work, you're asserting a kind of authority that has value that it doesn't have when the state publishes its poetry.
I understand, Mr. Citron, that the SG is essentially saying, well, for these annotations, the state is not telling you what it thinks about the law. The state is doing no more and no less than what Westlaw does. So the state's view of the law is just like Westlaw's view of the law. Why should we treat the two differently?
Well, I don't think they're the same for 2 reasons. One is these annotations are produced in the name of and the voice of the Code Revision Commission. And the Code Revision Commission is not a non-entity. Code Revision Commissions are responsible for assembling the text of the statutes and the other things that go into the official code. And look, in the United States context, 27 of the titles of the United States Code are simply the product of a Code Revision Commission. They aren't enacted as texts. So these Code Revision Commissions, they do exercise a legislative function. They assemble the text of the statute.
How's that different from the court reporter?
Because the court reporter isn't responsible for the text of the opinions at all, right? They're not allowed to move around the text and say, well, this would be clearer.
They're responsible for the text of what they produce as the summary.
What they add, they are responsible for, but the court is not responsible for it, and that's the big difference. Being the official reporter doesn't prevent you from adding whatever you want to the report. If Henry Wheaton had added things the court didn't like to the 1815 term report, they're not required to pay him for the 1816 term, but they can't pull the 1815 term report off the shelves. It's up to him what goes in that book. That's the complete opposite of what happens with Lexis and the OCGA. Lexis can't add one thing to the OCGA outside the state's authority. The hypothetical facts you pose, those are the actual facts of this case. The undisputed material facts are that all the materials in the OCGA are finalized under the direct supervision of the Code Revision Commission.
What's the difference between the commission and the reporter? I'm sorry.
The difference between the commission and the reporter.
The court reporter.
The commission.
In other words, how do you deal with Callahan and Wheaton, I guess, and how, if we're going to bring in the Sixth Circuit decision and how?
I think the difference is that the classic judicial reporter, particularly in the 19th century, which is what we should try to keep in mind, spoke in their own voice when they added materials to the court's opinion. The Code Revision Commission does not speak in its own voice. It's not like Westlaw, something you read on the Internet. It's speaking in the state's voice when it puts the annotations in. The annotations may not be very valuable. They might not be worth a lot in court, just like legislative history in front of many judges is not worth a lot in court. But it's still an authentic state legal document. It still comes through in the voice of the state.
Does this amount to anything other than the label that's put on this volume? Suppose they made it clear in labeling the volume that the law itself is the official. The code itself is the official law of the state of Georgia. All of the rest is not official. Would that take care of the problem?
I don't think it would take care of the problem in the following sense. If the state is the one that actually puts together the annotations, and it's known that these are the state's annotations, labeling part of it official and part of it unofficial is not going to do the trick. But that does go a long way. I think our main objection is when you confer officiality on these documents and you speak in the state's voice, that's the thing you can't copyright. If they wanted to have the official code of Georgia with annotations by Lexis, they could certainly have that.
Mr. Citron, in both Wheaton and in Callahan, both opinion mentioned that the cover pages said that these reports were by the individuals, not by the state.
Yeah.
And so the state wasn't claiming ownership or title to these annotations, correct?
That's right.
That's different from here, where neither Lexis nor, am I wrong? I don't think the annotation tells us who prepared the annotations, or does it? I didn't look specifically.
I mean, the reason the 11th Circuit got confused about whether these comments were who they were authored by and whether they were distinguishable from the other kinds of annotations in which they claim copyright is there isn't anything on the face of the annotations to tell you who wrote them or who's responsible for them.
All right. Could you please take the government's test? You articulate it, and you tell me why their conclusion is wrong under their test.
Well,
I know you don't accept their test, so don't fight the hypothetical.
Okay.
Okay?
Yes.
Accept the hypothetical.
Yeah.
And tell me why they're wrong under their
I think
their test.
The simplest understanding is the following. The Code Revision Commission is in two critical respects like the legislature or exercising a legislative or lawmaking function. First, it discharges its duties entirely at the behest of and for the benefit of the legislature, and the Georgia Supreme Court has told us that this is an exercise of the legislative authority for purposes of Georgia constitutional law. So trying to draw some line between the Code Revision Commission and the legislature would be, I think, inauthentic.
That's a really good answer. It's a really good answer from him because, like, you know, states are in control of their own state law. And so, like, is this entity part of the legislature or not? You know, it might be a factual distinguishment. Now, just because they're not part of the legislature doesn't mean that you necessarily would come to the opposite conclusion, right? So, like, are they part of the legislature or not? You know, it may or may not turn on that. But here, Georgia said, well, they are part of the legislature. And therefore, they are part of the legislature because Georgia is in control of its own state law. So they get to make those kind of determinations. And so if this is the legislature doing it, then it's just like the legislature themselves, then it's just legislative action, right? So might as well be the legislature who did it. It is the legislature. Oh, that's a pretty good answer. And I really like that answer. Relies on a state-specific issue. And that might be potentially grounds to separate what Georgia is doing from what other states are doing. I think a lot of, like, it's possible to write this decision in such a way as to only basically apply to Georgia and its fact pattern. So it depends, like, how broad the U.S. Supreme Court wants to be. Personally, if Justice Blackleaf were a member of this court, Justice Blackleaf would probably be looking to write an opinion that says anything that is adopted by any government entity as having the effect of law, regulation, or whatever is non-copyrighted. And yes, that includes all those wonderful manuals and stuff on how to build houses and electrical guidelines and plumbing, all that stuff. So if a state entity somewhere is adopting it and says, this is our official manual on how to do X, that becomes non-copyrighted. So that would be what I'd be writing if this were me. And yep. So, and I think about overturning the precedent dealing with the judicial annotations too, especially when they're being done by a state reporter. So I'd be thinking about overturning some precedent while I'm at it too, because I'm the Supreme Court at this point and I can do that. Let's read on or listen on.
On top of that, code revision commissions are exercising a legislative function. They assemble the text of the statutes. If you were to adopt a rule that the Code Revision Commission does not speak for the state, in states like New York, where the statutory text is put together by a Code Revision Commission, you could copyright the statutory text itself, because those statutory texts are just evidence of the law. They're not binding or the force of law vis-a-vis the statutes at large or the like. And, but for Section 105, Title 42 of the U.S. Code could be copyrighted too.
Mr. Schiffern, may I ask you a basic question of what matters here? One thing is that the annotations have the official state imprimatur. And you
Evil Tribble, you're right. This is not going to help me overturn Chevron. But I could overturn Wheaton and overturn those other cases, you know. I'll overturn those cases. Yeah, but maybe I could just put it in a footnote. I'll just put it in a footnote. By the way, even though this has nothing to do with it, just for the record, Chevron sucks. Just put it in a footnote put it in every footnote of every opinion. Just by the way, it has nothing to do with the issue at hand, but Chevron sucks. That'd be good.
Say that that's what matters. But why instead shouldn't it matter that these annotations are in no sense the law? They're just useful information on how the law has been interpreted and applied by others.
I think it's what you mean by in no sense the law, which is, I think, a complicated concept. When it bears the state's imprimatur, it is the law in some sense. It may not be worth very much. The state can say, look, this is just informational. Just the way the IRS, when it puts out an FAQ about how to file your tax return, says, look, this is just informational. A court might take a different view of it. But when the state is telling you this is a good summary of of the case, you're going to treat that differently. And it's not for nothing.
Well, they're not saying
Evil Tribble, are you mocking my disdain for Chevron? You're the one who brought it up in the first place. You know, so it's like you can't like bring it up and then me rant a little bit about Chevron and then give me a hard time for ranting about Chevron. You're the one who brought it up, Evil Gerbil.
A good summary or a bad summary. They may take comments from both sides, one interpreting it one way, one interpreting another way. They're useful aids to research. But you say that doesn't matter, that these are information, just information about how the law has been interpreted and applied without making any judgment whether those are correct or incorrect.
Well, the best I can say about it is this. My colleague said, I think the comments, which are often used by courts as an authentic source of law, probably shouldn't be copyrighted because they are offered as an intended gloss on the code. In their complaint, this is what they say the judicial annotations are there for. Quote, they must be carefully crafted by Lexis in order to illustrate and interpret the code sections of the OCGA. That's what they're there for. The state puts them there to illustrate and help interpret the code for its users. They aren't the law. You can't cite them in the sense of saying, I know the statute says this, but look at this annotation here. Just the way the notes that are at the end of the Federal Rules of Civil Procedure aren't going to overrule the text of the rule. But they do count for something because they come in the state's voice.
That's, I think, the question. I agree you've clarified everybody to me. The question is, what function does this particular set of words play in the law? And if we look at the precedent, I'm back where Justice Ginsburg was, because it's hard for me to see that it plays much more of a precedent than Wheaton. Much more of a role than Wheaton's annotations. And I can think of cases where a lot of people would say in respect to Westlaw, in respect to Lexis, and probably here, yes, that's what they say. But go read the case, my friend, and it isn't as good a summary as you think. All right, so what you'd have to show is that the official Westlaw actually plays a larger role in the law, in a lawmaking
I don't understand this question.
than does Westlaw. I doubt that there's something here that shows that.
I literally do not understand the words. I'm having a tough time parsing that question. I don't know if it's just me, but I'm having a difficult time parsing what he's asking. I don't understand the question.
Maybe there is.
I'll give you my best shot, okay? There are no cases in Georgia that have ever cited West's unofficial annotated code of Georgia because it's not official. And it's not something you would bring to court and say, well, look, an editor of Westlaw tells us that this case is relevant or that this statute became effective on this date. There are lots of cases that cite the annotations to the OCGA as such in Georgia for lots of different kinds of propositions.
But I think one question that is, I think Justice Ginsburg asked it, is some of your examples, they're government documents with a point of view. And when you think about one of these annotation books, it doesn't look like it has a point of view. It looks like there are annotations of cases on both sides of an issue. And as long as we don't have any sense that the state is editing in order to create a point of view, why doesn't that make a difference?
So that's true of the judicial annotations because the judicial annotations are themselves summaries of the cases. I would say they have a point of view about the cases. They will tell you what they think is important about those cases. But they don't purport to comment, this was a well-decided case, the reasoning here is poor. I will say the state wants to focus on the judicial annotations because it's hard to imagine using them this way. You should really focus on the editor's notes, which are also an annotation over which they are asserting copyright in this case. I want to bracket, they claim copyright over everything. In this case, they decided not to assert against some of the works, including basically everything in the code. They claim it. But the editor's notes, the editor's notes are notes that appear in the OCGA that describe things like when this code provision becomes effective, whether it was the product of a veto, override, or how it was enacted. And it can be extremely important to deciding a case. So one of the cases that we point to where an editor's note was cited is cited for the proposition that the state changed the rule for when a breathalyzer test was admissible. And it did so retroactively to all cases that were pending at the time that it was signed. The state cites, the court cites the editor's note for that proposition, and that's the reason this person is acquitted.
Is there any other source for that proposition?
Sure, you could go back to the statute at large, just like you could for all the non-positive law titles of the U.S. Code.
So if there were an award given out by the Law Review Commission every year for the best treatise in a particular area, in other words, we think this is, the best treatise, and as a result it's cited more frequently and more authoritatively than other treatises. Is that changed the copyright status?
I don't think so, because I don't think that treatise is still speaking with the authority of the state. They can say, this is a good treatise, in general you should look at it, but none of the propositions there have been adopted, and the treatise author certainly doesn't write with authority.
The fact that the courts are going to cite that treatise, and with some probably more frequency than others. So the fact that you have this editor's note that tells you it's retroactive, that's not what makes it retroactive. The fact is there's something else that that editor is looking at, and that is the official source that makes it retroactive. The fact that they cite the particular notes for ease of reference or because that editor has developed a reputation as being particularly good, seems to me doesn't transform the nature of those notes.
No, I will admit to you at the end of the day that the statute at large is going to control over the editor's note. The editor's note doesn't have the force of law as such, but that can't be the rule.
It would be, by the way, so I'll pause just for the practice tip. There's a good practice tip in here that shows you that you don't always have to fight every point as a lawyer, and it's always helpful to look for ways to give up ground or without having to give up much. And so this is a good example of it, right? So Justice Roberts is saying, it's not this is what matters is the text of the law, not these editors' notes. He was saying because the guy before was saying if the editor had said it becomes effective on this date, someone cited it, that helped got a guy off. And so Roberts said, well, it wasn't because the note that he got off, it was in the statute. So it wasn't because the editor wrote that it changed the outcome. You could have gone back to the original. So these notes are they're not changing the outcome. And so he says, yeah, you're right, it's not changing the outcome. So he's giving a concession. But then he's saying, but that can't be right if that's the rule, and he's going to go into why. So he's rather than saying I'm going to fight you, I'm going to say, yes, I'm going to accept your premise, and with your premise, my conclusion still follows. So it's a good note. It's a good way to, you don't want to fight everything because it just gets tiring. No judge likes it. It just gets way tiring, always fighting all the time. And so if there's a way to give some ground and concede something and it doesn't matter and you can still win, I can win under your premise, then, and recognizing that moment and being able to do that when you can, it's a sign of a good attorney, to be able to do that. And, you can obviously go too far the other way, right? You can obviously concede too much. So you could give up everything and just lose the argument. So it becomes an art form of, knowing when and when not to do it. And you have to do it on the fly, and you have to do it under a lot of pressure because you don't have any time to think. So it becomes, something that's very difficult as a balancing act. But just wanted to highlight this as a practice tip. This is a good example of a area where it's I can concede it, still win. It's nice. So I just thought I'd give a note there. So
wildly under-inclusive to exclude all the things that aren't the best authority at the end of the day. Like I said, all the non-positive law titles of the U.S. Code are like that. They are only prima facie evidence of the law, and you have to point back to the statute at large if there's a dispute to say what the law is. But if that's the rule, like I said, the actual statutory text in the official codes of most of the states can now be copyrighted, because that's what code revision commissions do. They put out these non-positive law titles that are prima facie evidence of the law. They still have a legal effect. They just aren't the controlling authority.
There's a lot of Go ahead.
You gave us a two-part test. The first part is whether it's a legal work. What does that mean?
It's just a work. Legal work's going to do one of two things. It's going to purport to state what the law is or interpret it, or it's going to be a part of the process of making it. And it's not intended to be, a complicated doctrine. I think it's pretty easy to look at a work and determine whether it's a legal work or not.
There's a lot of debate about what the precedents mean here. Should we interpret them in the direction of the text of the Copyright Act, which clearly says states can get copyright protection for annotations?
I mean, states can get copyright protection for annotations only insofar as they meet the authorship requirement of the Act. The authorship requirement was given a gloss in Banks. Banks says it got that gloss in Wheaton under the Marshall Court, and Congress has not seen fit to change it.
What about Howell? Do you accept Howell as correctly decided, the Sixth Circuit decision by Justice Harlan?
Yeah, we accept Howell as correctly decided, and we think it's a good case for us.
Explain that.
Okay.
It doesn't seem that way to me, but
I'll give it my best shot. So it's really important to focus on the order of operations in Howell and how it's different from what happens here. So in Howell compiles, acting on his own, a compilation of the Michigan statutes together with his own annotations. After he does that, Michigan passes a statute authenticating just the statutory portion of his work. And it says you can treat that statutory portion as though it were published under the authority of the state. And that causes Justice Harlan to write an opinion that says, even though Howell did that work on his own, you can cut and paste that text directly out of his book in order to republish a compilation of the laws, because no one can own the laws. The other stuff, which Howell had produced first on his own and the state had never authenticated, remained Howell's property. The exact opposite happens with the OCGA. Lexis produces the annotation for and at the commission of a state commission. The state commission exercises supervisory authority over what those annotations say. The legislature then requires that those annotations be merged into the official state document, and then the whole document is published under the authority of the state of Georgia. If that's what had happened in Howell, I don't think you could copyright the annotations.
The merger can't make the difference, though, right?
No, I think the merger does make a difference, because that is the legislature deciding that these annotations will be part of the code and then publishing that code under the state's authority. It could do the opposite. It could say, we are only if it had the authentication that's in the addendum saying the statutory text is authentic, you can treat it as good for site checking, that's fine. That's not making the whole volume official. The problem is publishing the whole volume under the authority of the state, including the annotations, and then saying, well, actually, these annotations aren't special. They're not distinguishable from what Westlaw does or anyone else.
But if you cited the annotations as binding law, that would be wrong.
Well, two things about that. One is,
or even instructive, it would be wrong.
I don't think that's right. If you cited the judicial annotation in court, you said, I found this in the OCGA, and I haven't checked the case, but this is what the case says according to the OCGA. I'm not sure a court would treat that as incorrect. That seems to be a plausible way to use it.
The court would correct me if I'm wrong, the court would do its own independent research to determine the weight to be afforded that authority.
Right, but it does that with lots of things that we all agree are the law for purposes of this copyright rule. Mm-hmm. Just like when agency tells you what one of its documents means. You're going to construe it. You're going to use your own judicial authority to attempt to determine what it means before accepting the agency's determination. But it still could be a good starting place. It wouldn't be the same if it was just something you read on the Internet.
Can I ask you a question from a different direction, which is the state's amicus brief, which is a cross-section of states, makes a very strong argument that this is going to create problems in terms of incentives for creating these annotations in the first place. And so the net result of your position, if it wins, so the state's claim, is that there'll be fewer of these annotations. Can you respond to that?
Yeah, happy to. If the proposition, which has to be Georgia's view, is that the annotations are just the same as private annotations, there is at least one, and usually two, privately annotated legal codes available for every state in the union. And that includes states that don't copyright anything, and it includes states that make an annotated code available on the Internet for free themselves. So the incentive to create these private works is not going to be affected at all.
So the states are just wrong about that? I mean, isn't there a cost-price issue that's involved? Or why are the states saying that if they have nothing to fear?
I don't think the states have anything to fear. What they want is the official versions to exist. The official versions bear the state's imprimatur. They get to supervise what goes in them.
Imprimatur.
That's the source of the problem with the copyright.
That's cute.
But
he says bears the state's imprimatur. I've always heard it pronounced imprimatur. Imprimatur. He says imprimatur. I don't know if those are two different pronunciations, but I just take note because I've always heard it pronounced imprimatur. So
the official versions bear the state's imprimatur. They get to supervise what goes in them. That's the source of the problem with the copywriting of it. But the unofficial and the annotations themselves will exist without regard to whether or not this kind of copyright.
I thought that Mr. Johnson told me that they would be more expensive. Do you dispute that?
I do dispute that in two respects. One is the actual useful versions of these codes are already plenty expensive. There's a lot of discussion of the cost for printed volume, but online access, which is what really most practitioners need to use, most people want to use, it's much more expensive than the $400. But even accepting that the price is lower, I think that favors us. Because what's going on there is an exchange you're going to accept a price cap in exchange for the right to publish this officially, not for publishing the annotations. Because Westlaw makes the annotations and is allowed to charge 6 times as much. Lexis isn't going to agree to do the annotation work in exchange for a price cap. What it wants for the price cap is the right to publish it officially. I hope that makes sense. There's a good description of this in a brief from some former publishing officials that explain, if this is what's going on, Lexis is essentially being hoodwinked.
What is your best evidence that the state actually edits what Lexis does or supervises the substance of what Lexis does?
Well, so there's a couple of things in the publication manual that set forth how Lexis is supposed to communicate with the state, and it requires sending them memos with bracketing around what the new material is, Xeroxing the pages on which any ALR notes or opinions of the Attorney General might be deleted and pointing them out for state approval. The publication manual also highlights situations in which the state is likely to tell them what kind of editor's note to create surrounding complicated amendments or the like. So the Commission is involved, but we don't have, because the case was decided on summary judgment, we just don't have a record of how often the Commission actually...
I just thought of possible. This has shed a lot of light in a number of areas. One of those areas is only applicable to some judges. Some judges do look at legislative history. So for those who do look at legislative history, a committee report has significance. All right? Now, take the same words and imagine that a senator, long afterwards, came into court and testified, that's what we meant. Would we give that senator weight? No. Mm-hmm. Or suppose that the committee met after it was passed. That's called post-enactment legislative history. Does that have some weight? Usually very little. And that's because that isn't normally their job. That isn't normally part of the lawmaking process. Thinking of that analogy, it seems to me that your case lies somewhere between the official post-enactment legislative history and over here the senator walking into the courtroom and just saying that's what I meant. Now, is that fair? Because I don't think you like me thinking that way.
Oh, I'm comfortable with you thinking that way. And I think that that's one of the main points I've been trying to make here. There is a difference between being worth very little, but nonetheless being official, authentic state legal resource, and being worth nothing because you're not an authentic state.
Good answer. That's really nice, really sharp, and I have to give him bonus points for that. Justice Breyer said, there's this stuff that the legislature does is basically crap, and we know it's crap. And he basically said, yeah, it might be crap, but it's official crap, and the fact it's official crap makes it all the difference. I'm like, yeah, that's a really solid answer to this problem. It's like, yeah, this whether or not it has any sort of impact for you judges, some judges completely ignore legislative history. Some don't like this and, it's after the fact stuff. Okay, it's crap, but it's official crap. So it's like, and that's exactly what's going on here. There's a difference being official but worth very little and, being worthless. Or being worthless and being official and even being very little and worth and nothing. So I like, very nice answer. Very sharp answer. Good job.
Legal resource. It's not even the senator walking in and testifying, right? What we need to compare this to is somebody from the New York Times walking in and testifying that this is what people had in mind when they enacted the statute. That's not good for anything because it's not a state legal resource. It doesn't speak in the voice of the state. And you can disagree about how much weight to give something that is nonetheless an authentic state legal resource. But that's the thing that makes the difference. And that, again, is the difference between these cases and Howell and Wheaton. Howell and Wheaton were allowed to add whatever they wanted.
Presumably a certified copy of the committee report would not be post hoc.
I think the point I was trying to make is post hoc or not might affect how much weight you want to give it. But the fact that it's a certified committee report is the thing that really makes the difference.
Now, I understand Justice Ginsburg's question because I do think the comments troubled me, taking the government and petitioner side. The editorial notes trouble me, but most of the references in the notes are just to judicial decisions and or general research matters. If it were limited just to that, why can't the state?
I'll just give I'll try to give you the best example we could find. In one of the state cases that cites a judicial annotation, what happened was a lawyer from Florida didn't file a response to a motion for summary judgment because he looked up the statute, and the statute says there's going to be a hearing in 30 days. You can file something up until the hearing. Turns out that there's a rule that says, no, you have to file a response, or else it might be deemed forfeited. And the court is deciding whether his failure to file a response is excusable neglect. And the court says, well, if you look at the annotations to this statute, it discloses the existence of Rule 6.3, which is not inconsistent with the statute. And this is what happens when you have a state legal manual, like the OCGA, that has official annotations in it. Courts will find ways, and regular people will find ways, to attribute importance to things that are difficult to use for judicial purposes, but sometimes will. And the reason they do that is because this is a legal work that speaks in the voice of the state and not just the bare work of some.
Dogbert says, I was hoping for the New York City case. All right. I put this in the comments. I'm going to say it because Evil Tribble was haranguing me about it before, and no one wants to read the comment. All right. I perused the transcript of the New York City case. It basically all goes to mootness and whether or not the case is moot. It is really technical minutia. It's nothing dealing with the Second Amendment issues. It's very technical whether the case is moot minutia. And there's like a 90% chance the case is going to be dismissed as improvidently granted based on what New York City did because the case is now moot. So we're not covering the case because I was all excited to cover the case because I am a Second Amendment guy. All right. I'm a Second Amendment guy and I would love to cover the case, but it's not dealing with the Second Amendment. It's dealing with mootness doctrine and it's very, very technical. And I put this in the comments for the description to this video so that people would see why I'm not covering that case because it's not interesting. it's a very technical case dealing with mootness doctrine, and it's like, moving on.
One who happens to be a legal editor at Westlaw or something like that.
That would be a mistake, right? I mean, it would be a mistake to attribute the significance to it.
I don't know if it would be a mistake or not.
Under state law, it would be a mistake.
I mean, what they did was attribute significance to the fact that you could find it there in the manual when they were trying to figure out.
But under state law, that's wrong?
Well, no, the state law would say that it would be wrong in construing the meaning of that statute, but it isn't necessarily wrong for figuring out what's excusable neglect, right? Whether it's good lawyering or bad lawyering, not to look at the annotations in the OCGA isn't governed by the statute. The statute doesn't say, Section 111 doesn't say anything about that.
Well, but it would also be pertinent to the question of excusable neglect to look at what, all the treatises said. I mean, if I'm writing an opinion about whether the lawyer should have known that, I would say all the treatises about Georgia law, highlight the fact that you've got to file a response.
I think you and I may have different instincts about that. I think it'd be more appropriate for a judge to say, well, look, in the official state legal code, there are annotations that point to the rule that you neglected. I think that's more persuasive. That's different than saying, well, if you happen to look at the unofficial codification that Westlaw does, there's an indication that that rule exists. That's the difference.
Thank you, counsel. 3 minutes, Mr. Johnson.
I want to start briefly by talking about the different portions of the OCGA, things like editor's notes. We talk in our brief about why the editor's note should be copyrightable, why the Dominique case that my friend on the other side just was describing doesn't undermine our copyright claim. But I think the crucial point on this is that PRO copied the entirety of the OCGA, including the judicial decision summaries that I think are clearly copyrightable under Wheaton and Callahan. So PRO has to run the table on all portions of the OCGA to get an affirmance here, and I just don't think that they can. The PRO's main argument seems to be that the fact that the OCGA is official means that it cannot be copyrightable. And I just don't think that that's consistent with history or this court's precedents. Again, going back to Wheaton and Callahan, you had official court reporters holding copyright in annotations. And given that those were government officials, I just don't think that it can make a difference here that the state is the one holding the copyright. I think that this case is the legislative analog of Wheaton and Callahan. But I think it's also important to look at the history of the Copyright Act. So the Copyright Office in the 1959 study and 1961 report interpreted the 19th century precedents we're talking about here as holding that states could hold copyright in annotations by state government employees. And then Congress passed the Modern Copyright Act without in any way overriding that understanding or expanding the government edicts doctrine. Under that understanding, we win here. And then the final point that I want to touch on is how affirming the decision below would be very disruptive for states. So about a third of states have the same regime as Georgia. They claim copyright in annotations to an annotated official code by commercial publishers. So affirming the decision below would blow up those regimes. There are at least 2 additional states that claim copyright in annotations by state government employees, and 5 other states where the commercial publisher holds the copyright in the annotated official code. Those regimes would probably also fall if the court's decision below was affirmed. So I think that statutory text and precedent compel a decision for Georgia here. Any innovations on the government edicts doctrine should come from Congress, not the courts. The court should reverse.
Thank you, counsel. The case is submitted.
Okay, well, I think it's a closer call than when I started this issue. I think Georgia made some really good arguments and really good precedent. I have no basis on which to revise my prediction, though. I think it's closer than it was because of the precedent dealing with judicial annotations and dealing with official court reporters who are adding annotations and headnotes. Like, an official court reporter is an employee of the judicial branch, which is therefore part of the state. They're producing stuff that's copyrighted, which is distinct from the judge's decision, and this in the same way. But then again, of course, you get that back end stuff and like the reincorporation. So like basically, and he's also pointed out that, if I understood him correctly, that like things that people concede are copyrighted, like some of these judicial headnotes, are actually in the Georgia Revised Code. So therefore, those portions still maintain the copyright, even though they're in the code. But again, my analysis would be like on the back end, because Georgia took the step of making it part of their actual code. Even though it doesn't have the force of law, it's part of the law, which makes sense. It doesn't have the force of law, right? Because it's like, it's not something that you could execute against, right? It's a commentary. So it makes sense that it doesn't have the force of law, because there's like no way to break it. You know, it can't have the force of law if there's no way to break it, right? There's no way to break a comment. So it makes sense that it doesn't have the force of law, but it's part of the law, according to Georgia. And I think that makes all the difference. And again, to the extent that that means that Georgia has appropriated the copyright interest of any of these people, then they need to work that out differently, assuming they can. And as I point out, there's a case in the Supreme Court this term dealing with whether or not you can sue a state for copyright infringement or not. So, you know, it may be the case that if that case goes the other way, that they've stolen your copyright and you have no remedy, which kind of sucks. But I think that that's, you know, that's not, you know, whether or not you have a remedy for the copyright violation is distinct from whether or not, you know, your copyright has been appropriated. And maybe you just have no remedy, because it's an act of the state to say what its law is. The state has an absolute sovereign right, period, to say what its law is, and up to and including them incorporating the entire text of the entire Harry Potter series as part of their code. They can do that. They have the absolute sovereign right to do that. And the fact that they did it means J.K. Rowling has no remedy, because it's just part of the law now. So, you know, that's sort of like how I'm thinking about it. And the distinguishment for me, either I'd strike down the old law, which I'm tempted to do, but you know, as a conservative, conservatives tend not to let, you know, I don't think they like to overrule precedent unless they have to, and it looks like I can distinguish on the facts, because that, you know, whereas the reporter just publishes it separately, the state, by reincorporating it, takes official state action, and that's enough to separate it on the facts. So that is sort of what I'm going. So Evil Tribble says, if the government infringes your copyright, isn't that a seizure? Yes, it is a seizure. The issue isn't whether it's a seizure. It's an issue of whether or not you can sue for it, because it's not clear that when Congress passed the remedies under the Copyright Act that they took away the state's sovereign immunity. So yes, it is a taking. It's just a taking for which the issue is sovereign immunity. It's the state. And like, you can't sue the state unless the state says you can. And so it would be an issue of sovereign immunity. So yeah, it would be a taking for which you have no remedy. You have no ability to sue. So, and you'd be citing like 11th Amendment doctrine under that. So yes, it'd be a taking. It's just taking you can't do anything about. So yeah, that's the issue being decided in that case. Seindinger, Fifth Amendment, not Fourth. Taking is Fifth Amendment, eminent domain. And no, still the issue is not whether it's a violation of the Fifth Amendment. The issue is the sovereign immunity doctrine. The 11th Amendment. The problem is the 11th Amendment to the Constitution says that you can't sue you can't sue the state in federal court, and you can't sue another state in federal court. So the Constitution prohibits you from suing in federal court. The copyright law is federal law. So the 11th Amendment prohibits you. So the Fifth Amendment says it's a taking. The 11th Amendment says you can't sue the state in federal court over it, and the copyright law is a federal law. So that's the problem. It's a taking under the Fifth Amendment, but the 11th Amendment says you don't have jurisdiction in the federal court, and the only thing that's stopping you is the federal law. So you can't sue them because of the 11th Amendment. Now, under Ex parte Young, there's this case, Ex parte Young, you can enforce federal interests in federal court. So the issue is whether or not Congress created a remedy that you can apply to the federal court, apply to states in federal court. So it's like, when they applied this, did they waive the sovereign immunity in the way that they wrote the copyright statute? So it's a very sort of like technical argument. But yeah, the problem is like whether or not the sovereign immunity has been waived or not. So that's the argument over there. But again, all that has nothing to do with like, for me, on like, if the state took the copyright or not. Maybe they took the copyright and there's no remedy, but that's another problem. So, yeah. Stamp had a state, but you see there, when they talk about the stamp, that's the federal government. The United States Postal Service is part of the federal government, not the state government. We're talking about state governments. This is federalism, guys. This is federalism. You know, you can sue the USPS in federal court because they're part of the federal government. We're talking about suing a state government. So yeah, you can sue the USPS for copyright infringement because they're part of the federal government. The question is, can you sue the state of Georgia for copyright infringement? They're not part of the federal government. So that's exactly the 11th Amendment. That's Ex parte Young. That's sovereign immunity. All that good stuff. So that's the distinguishment. That's the separation. It's the federal government versus the state government. You can't haul the states into federal court unless there's a federal law specifically saying that you can. So that's the issue. That doesn't apply to the USPS. They're not part of a state government. So there's your massive interaction between Fifth Amendment, 11th Amendment, Ex parte Young, and federalism. So we just discussed 4 constitutional issues for the price of 1. Very exciting. How was that fun? Anyways, so let's talk about the New York State Pistol Rifle Association case a little bit, because I'm being harangued, and so we'll talk about what happened in that case, or what is happening. So here's what happened. Didn't this come up with the pirate ship video? Wasn't that the state? Yes, that's the case that's being decided. That's the case. That's exactly the case that is being decided this term, is the pirate ship video. Yes, that is that case dealing with that issue. So you're 100% right. So that is the case trying to decide whether or not the state can be sued. The United States Supreme Court is deciding that issue right now on the pirate ship case, because yes, it's a state entity and someone tried to sue them in federal court, and the issue is all the things I just said. So it's like, did Congress give a remedy in the copyright statute to sue the state over this pirate tape or not? So yes, you're exactly right. That is the case. So whether or not they stole your copyright and whether or not you can sue them over it are 2 different issues. So yeah, you're 100% correct. Hit that like button, yes, and give me money for Patreon, please. Yeah, so let's talk about the New York State Pistol Rifle Association. I'll just talk about it because I skimmed the transcript. It's very technical in a way that is like just not interesting. It deals with, I mean, it's barely interesting to lawyers. In fact, it's really not. But let me tell you what happened in the case about it. Okay. All right. So New York State and New York City, more particularly, had a regulation on the books, and this regulation applied to a permit license to own a handgun. So New York State, New York City has at least 2 different kinds of gun licenses. They have a premise license and they have a carry license. A carry license allows you to carry a firearm, concealed carry. A premise license allows you to have a handgun in your premises, whether that's a business or a home. The way that the regulations in New York City were drafted, it said you could take the handgun on an uninterrupted trip to like any gun range or like gun store, gunsmith within the 5 boroughs of New York City. but you couldn't take it from one home to another. So if you happen to own 2 homes in New York City, you couldn't take it from one home to another, and you couldn't take it to a gun range outside of the 5 boroughs. So not just out of state, but outside of New York City. So if you had a premise license, you had to take it to a shooting range within the 5 boroughs, and it had to be an uninterrupted trip, and that was what was going on. The Court of Appeals ruled that this was totally cool and totally not a problem. And the New York State Rifle and Pistol Association applied for certiorari. And the city of New York, or state of New York, I forget which one actually filed the brief, not that it really matters in this context. But the state of New York filed a brief on the question of whether cert should be granted, which is very typical. And they basically said cert shouldn't be granted. They said, there's no conflict. This is our law. We totally are proud of our law. We think our law is the greatest. We're really proud of our law. The court below said our law is totally cool. There's no reason for you to take this case. We stand by our law. Our law is totally great. Then the United States Supreme Court granted certiorari. Then New York went into a panic. New York panicked. And this is not the first time we've seen this happen. For those of you who may not remember, and I wouldn't expect you to, Illinois at the time had no issue permit. So some states were shall issue, some states are may issue, and some states were no issue. So Illinois had a no issue. They didn't issue concealed carry license or open carry licenses to anybody. Illinois lost in the 7th Circuit Court of Appeals when that issue came up. And Illinois decided not to appeal. Illinois changed from no issue to shall issue to avoid that issue going to the United States Supreme Court. Same thing happened to Washington, D.C. Washington, D.C. didn't issue permits to anybody. They lost at the Court of Appeals for the D.C. Circuit. They decided not to appeal. They went from no issue to shall issue. It's a bit of a cumbersome shall issue, but still they will issue a permit to anyone who is qualified. And there was the case of Padilla in California, where California basically changed the rules to prevent the Supreme Court from hearing the case. And New York did exactly the same thing here. So in between the time, but now this time New York had won below, so they didn't have the right to decide whether or not to appeal. They told the court they shouldn't, but they didn't have the right to decide. The court took the case. So New York went into a total panic because they don't want the Supreme Court to decide the case. They don't want precedent. What they're trying to avoid is precedent on a right to bear case. They're trying to keep gun cases out of the Supreme Court because they don't want gun cases being decided by the U.S. Supreme Court. They don't want precedent being set nationwide. So every time it has gotten close, every state has gone into a complete and total panic to do anything possible to prevent this from being heard by the United States Supreme Court. And that's exactly what happened here. The New York City Police, if memory serves correctly, very soon after certiorari was granted, published a new set of regulations. These new regulations said it's totally cool if you want to take your gun out of your house and take it outside the 5 boroughs. You can take it out of state. You can take it to your different house. You can take this gun anywhere you want. New York City, which had about 2 months earlier said we're super, super proud of our law. Our law's the greatest. It's totally necessary. We love our law. The law's super wonderful. 2 months later, the commissioner of police said, "Oh, we hate our law. No, that law's stupid. We don't like that law anymore. We're going to pass new regulations that say, you get everything you want. You get a car and you get a car and you get a car. Everybody gets a car, right? So we're going to give you everything you want in terms of regulation." So the police commissioner, as memory serves, put out a new regulation that says you can take your gun outside the 5 boroughs. You can take it to a different house. Oh, and incidentally, no one who has ever broken the law, and they said this in the oral argument, They said this because one of the things they asked about was, what about anyone who's ever broken the law? And the lawyer for New York said, no, none of those people are ever going to be punished ever. No, none of those people are ever going to be punished. We disclaim any right to punish any of those people. We're never going to bring a case for anyone who ever broke the law. And it's like, really? Because in the opposing side's brief, they have like basically 3 people who openly admit on the record in like Supreme Court filings, they openly admit in the filings that they've broken your law multiple times, and the attorney for New York is like, nope, it's totally fine. We're totally fine. They have no criminal exposure. We disclaim. We give up all those cases. They're totally in the clear. We have no interest in this. We give up. It's fine. So they get everything they want. No problem. And just in case that wasn't good enough, New York City ran screaming to Albany, the state capital of New York, and got the state legislature to pass a law like in like a 2-month interval. These guys are bawling. They are bawling. They are scared out of their minds. They run up to Albany and like, you got to pass a law right now. And so the state legislature passed and signed a law in like record time. Basically says the city of New York has no power to ever pass any regulation like this ever again. We, the state legislature, completely strip from the city of New York any power to pass any regulation like the one they used to have. New York City has no power. We, the state legislature, find this abominable. We totally destroy New York City. And New York City's like, yeah, we're totally cool with this. So that's basically what happened, is like they ran up to the legislature just in case and got a law passed that says you can never ever do this again. New York City, you are but a creature of the state. You will bow to our will. Blah. And so they got Albany to pass a law just to make sure that like, so it's like, well, what if, because one of the arguments is, well, what if you just change your mind? What if you just like change the regulations? So they went to Albany to get a law passed and signed that says, no, we can't even do that because it's now a violation of state law. We specifically prohibited ourselves from ever doing this ever again. We want none of it. We've given them everything they want, so they have no case. You know, Article 3 of the Constitution applies to cases and controversies. You know, the Supreme Court of the United States does not do advisory opinions. They don't do what would happen if. They only do live cases and controversies. It's in the Constitution. So it's not so much as they don't as they can't, at least as far as the constitutional text is written. So this is what the entire argument at the Supreme Court turned into, was an argument over like whether or not it's moot or not, whether or not there's actually a case. And New York's entire argument was there's no case. There's no case of controversy. There is no exposure. We've given them everything they want. We've changed the regulation to be exactly what they want. There's no exposure, and we sitting here today, as the lawyer on behalf of New York, the lawyer on behalf of New York, am here to tell you, the Supreme Court, that we will never, ever, ever prosecute these cases. And incidentally, by the way, that is absolutely a binding statement. So like when they say that, that's like actually true. You can't just say that. That's like when you say that to a court, when you say that to the U.S. Supreme Court, it's true. So like that's not something they can change their mind on, incidentally. That's like we have given this up. I, on behalf of the state of New York, because I am the attorney for New York, I am the state, and I'm telling you that we are disclaiming this. We have no claim. We're giving it up. And you can do that. It's one of the many wonderful powers you get as an attorney, right? When you represent someone, you can do shit like that and make representations and then become binding. So they said, so that was what the entire argument was about, was whether it's moot. And it got into really pedantic issues, like if there's any issue that wasn't resolved, if there was anything like any exposure, anything at all, that like, the one of the things they actually got into was, because it says in the regulation from New York that it has to be like, I think the phrase is uninterrupted and continuous. So like when you're taking your gun from like one place to another place, it has to be uninterrupted and continuous. And so there's some questions like, well, what does that mean? And like, and even then, New York was desperate for there not to be a jurisdiction, because it's like they're still in. This was basically the exchange. Okay, I'm paraphrasing, but this is basically the exchange. It's like Supreme Court says, what does that mean? Isn't there some exposure there? And Supreme Court's like, and the city of New York's lawyers like, no, there's not. They said, well, continuous and uninterrupted sounds kind of ambiguous. We're not sure what that means. No, it's totally fine. What sort of problems are you considering about? Well, what if someone stops for gas? No, they can stop for gas. Really? They can stop for gas? Oh yeah. They can stop for gas. Yeah. But it says continuous and uninterrupted. No. They can stop for gas. Totally fine. Yep. What if they need to stop for the bathroom? Oh, bathroom, totally fine. Yep. But it says continuous and uninterrupted. Yeah. But bathroom's totally fine. The bathroom, gas, totally cool. Yep. Really? Well, what if they have a flat tire on the road? Yep, no problem. Nope, that's fine. All that's fine. And like, it got down to the point, they literally asked this at the U.S. Supreme Court. I'm not making this example up. They literally asked, well, what if like you're visiting your mother and you stop at your in-laws' house? Is that okay? And they're like, well, we're not so sure about that one, but sure, why not? Even that they wouldn't say no, it wasn't okay. They wouldn't say yes, but they wouldn't say no. So even the like, if you're visiting your mother, can you stop at your in-laws? It's like, well, we wouldn't worry about it, and if it ever came up, but that's another issue for another day. And like, so New York City is desperate to keep this out of the United States Supreme Court. So, like, it was just a little funny in that way, watching New York City. Like, please, what do you want? We'll give you anything you want. Please, we'll give you anything you want. We don't want this case. Please, what do you want? We want this to go away. So that was what it's about. So what is the outcome going to be? Well, there is one doctrine which talks about voluntary cessation. If like this state is like voluntarily giving up their right to do stuff to avoid review, right? So they'd like drop this case, but they could bring it back. But that's one of the reasons they went to the U.S. They went to Albany, like running to Albany, because of the voluntary cessation doctrine. Because the voluntary cessation doctrine basically says, look, if you're just like dropping this case to avoid judicial review, but you can bring up it again, like, screw you. We understand we understand what you're doing. You're just going to drop this prosecution and prosecute the next guy and prosecute the next guy and prosecute the next guy. And anytime it ever gets to the U.S. Supreme Court, you're just going to drop that case. 99.9% of them will never get that far. And for the 0.1%, you're willing to sacrifice them to the altar of the law gods just so you don't have to do it. So there is this doctrine of voluntary cessation. It's like, if you're just like voluntarily doing it, we're going to say, screw you. That's exactly why New York City went screaming to Albany to get them to pass a law. It says, no, it's not voluntary. It's not voluntary. We had to do it. We had to do it because Albany said we had to. We can't just bring this law back. We have no power. We have no ability to bring this back. We can't prosecute. This is illegal. We can't operate in this domain. Woo! And so that's exactly why they fled to Albany, like running from the bulls kind of style, tripping over themselves to see how fast they could get there because of specifically that issue. And that's the reason they did that, is because of that issue. So like, even that is like, not really on the table. So I think the overwhelming odds are that the case is going to get dismissed as improvidently granted. It's going to get digged, and in light of the mootness, because it's like there's nothing to do. So that's why we didn't do the oral argument for Evil Tribble and Dogbert. That's why we didn't do the oral audio. The oral audio for the case, because I skimmed the transcript. I skimmed the transcript. It's really minutia on mootness doctrine. It's everything I've done in sort of describing it is way more interesting than the argument was. I have animated what was really a very boring discussion. So like, if you want to go read the transcript or listen to the oral argument yourself, it's like, it's posted. It's not like it's secret. Go listen to it yourself. I just don't think that there's anything interesting there. It's really like hyper technical minutia on mootness doctrine. And like, it's just like, it's too esoteric. It's too minor for us to talk about. Might the Supreme Court do something about it? Yeah, but like, I have no way to predict it. I have no way to do it because, like, the only thing the Supreme Court can do would be change the law. Like, if they follow the law, if they follow like what the law is, the answer is pretty easy. The case is moot. I think it has to be. And like anything else is speculative, and anything else is like, it's moot. So like, if they follow the law the way it is, it's moot. So like 98%, they're going to dismiss as improvidently granted because there's nothing to do here. They're going to dismiss as improvidently granted and be like, yeah, we just, and then the only interesting thing about it becomes whether or not like they do it in a one-word sentence or whether or not like people put in some opinions on top of it, whether or not they like expound on stuff for the record, because it'll all be technically dicta, but then again, it's Supreme Court dicta. So, people do take that seriously. So like, that's really the only interesting question is whether or not they write any opinion about it. But like, how am I supposed to be able to predict whether they write an opinion about it or whether or not they just dig it? I mean, I know what the outcome's going to be. It's 98% they're going to dig it. With or without commentary, I don't know. But that's really the only interesting thing. Like, the only other remaining possibility is, like, they invoke some, like, judo stuff about, like, ever recurring but evading review or, like, overturn mootness doctrine or something, like, massively, like, changing the law. But if they're going to change the law like that massively, there's nothing on the oral argument that indicates the court is interested in doing that. So there's nothing that I saw that says the court is like looking at massively overturning mootness doctrine. So like, I guess they could, but there's nothing on the like transcript that indicates anything like that to me, that like they're looking to do that. And if they do, it'll be a complete surprise out of left field. And there's nothing on the oral transcript that would tell us or forecast for us what that would look like. It would be a massive change in the law. And so I have no way to like see what that is because, I, as a lawyer, can make reasonable predictions based on precedent. And like, I can even make reasonable predictions on like overturning precedent sometimes. Cause I'm like, well, if you overturn this precedent, then like these kinds of results would tend to emerge. But like, if they do something here, it's like, I can't forecast it. There's nothing for me to forecast it against. It would be a very serious change in the law. And there's nothing for me to like forecast what that would be. And I don't think it's particularly likely because there's nothing on there. So I think that's why we didn't do the case, because it's just boring. It's very, very technical minutia. And so like, it's just nothing for us to talk about. So yeah. Maybe I'll clip that and post it as a separate story about why we are not talking about the New York State Pistol and Rifle Association case, because it is a whole bunch of like, it's just really esoterically, it's just really, really super technical. And like, there's a chance they could say it's not moot because of some minor point. Like, they'd have to reach to say it's not moot, to be really honest. I mean, for the Supreme Court to say it's not moot, given the precedent that exists, they have to reach pretty hard. I mean, they'd have to reach pretty hard. And it's really not, it's really not. I mean, like 99.5%, it's going to be digged because it's moot. And incidentally, like, it's not even necessarily that big a deal. Because, it's early enough in the term that the Supreme Court could add another case to its docket. So, if the Supreme Court really wants to do like a Second Amendment case this term, I mean, this is not like that's the only like case that's up for cert. Like they do get 10,000 submissions, literally 10,000. Every year. And of that, they hear somewhere between 80 and 120, depending on what year it is. And recently it's been more like 80. So they hear like 0.7% of the cases that come up to them for review. So like, if they want to do a Second Amendment case, there are other cases that are totally briefed, ready to go. Like, they don't have to like wait around. They can just like, okay, let's shuffle through the pile and find something else. So they could still like have oral argument on a Second Amendment case. So if they want to have the argument, I mean, there's other cases to pull out of the pile. So this is no longer, in this humble lawyer's opinion, this is no longer a good vehicle for this case, for this issue. This is no longer a good vehicle for this issue. So if you really want to do something, do it somewhere else. Don't do it here. That makes no sense. So that's why we didn't talk about the case, because it is now dumb. So, also, because it's my channel and I didn't want to. How about that? Well, Evil Tribble, I'm not sure what circuit split you're referring to. The New York City law was pretty esoteric, and I'm not aware of like any split. At least New York City, New York State in its brief said there was no circuit split because the issue is too small. Like, not to say that like right to bear in general is not a split issue. That's certainly split. But like there are other cases that are better vehicles than this. This is no longer a good vehicle for this case. It's a bad vehicle for the issue. So, you know, the circuit split gives you the interest of finding a good vehicle. So the circuit split gives you the interest in finding a case that will work, but this is not that case anymore. It's just not a particularly good case. So, yeah. Yeah. So that's what happened and why we didn't talk about it. So anyways, I got another super chat donation at one point, and I want to see if I can find it. Charles Forrest said $7. Read it for us. Yay. Well, we didn't have to read it for you, Charles, because somehow my audio cut out, and I thought that, you know, that we were dead, but it turned out we weren't. So we were good. But thank you for the donation for the $7. It is much appreciated. As I said before, you know, it does really help the channel and help me grow. So that's what's going on. So I hope you enjoyed this edition. As for this case, for the case we talked about today, I'm going to maintain on Fantasy SCOTUS. I'm going to maintain 9-0 to affirm. You know, I don't have any particular confidence in that result. But I don't really have any sense in my mind as to like where I think people are going to be on this. So I'm just going to maintain 9-0 to affirm. You know, make up your own judgment calls. I don't blame anyone who says anything different than that. I don't even blame anyone who says that this is going to be reversed, to be quite honest. But you know, I don't really have, you know, a lot of these cases I have a pretty decent sense on. Doesn't mean, of course, I'm right, you know, but in this case, I don't really have a particularly good sense of who's sitting where. So I'm just going to maintain it 9-0 to affirm and hope for the best. So we'll see. Not saying I'm going to be right, but that's what I'm going with for the minute. Anyways, if you have not previously liked this stream, and I know many of you haven't because I only have 20 likes, I'm looking at the rest of you, and Evil Tribble, if you haven't liked this video at this point, after that description of New York State Pistol Rifle Association, then I don't know what more you want from me. But if you haven't liked the stream, I'd appreciate it if you give it a like. As always, I have enjoyed spending this time with you. I have been your host, Blackleaf. Thank you for coming. Until later, my friends. I hope you're well. Cheers and goodbye.